Yes, Ms. Khan.
Well, just before I move on to take your lordships to further paragraphs in the Chukarova case, can I just mention three things which have arisen out of this morning? The first is the calculations in relation to what was due at any particular time in relation to any particular offer.
This is the 1.85 million.
Yes, my lord. Spreadsheets were prepared for the remitted hearing, which were in evidence at the remitted hearing, which are not in your lordship's bundles. I have got copies of those spreadsheets if your lordships would like to see them.
I think it might be useful.
Right. In which case, do you want copies? I think they were. Well,
Yeah.
they were produced, I think, at court.
Yeah.
The same thing, but with E3.
So these were produced for the remitted hearing.
Lord, that's
They weren't supplied to Gunnar Cook at the time. Is that right?
correct. Let me just. Thank you.
They weren't actually given to the judge, were they?
I think they were.
We agreed that you were right that the
Yes.
numbers were lower than the rough.
Well, well, in a friend's recollection, he may be right about this. I wouldn't. It's not a hill I would like to die on. Is that because it was agreed, because the figures were agreed between he and I at the remitted hearing, he's not sure that this was ever put before the judge.
Oh, I see. But anyway, this is the basis of the
This is the
agreement.
basis upon which.
Right. All right.
You'll see that the second box down has paragraph 16.1, 16.2. So these are the offers
Yes, I see.
with the payment date, the number of days, the interest due, the retained interest less the interest due, and therefore the total balance.
Yep, I follow.
So in fact, I think I said 1.805 this morning, which was wrong because that's slightly later. That's the May 2021 position. In fact, it doesn't get for the three upon which we place particular reliance this time. It doesn't get above 1.783.
Yes.
Is the sum actually outstanding? Well, the second point was that we did check our skeleton to have a look and see the way in which we had advanced the case that your lordship asked me about this morning. Can I just invite your lordship to look in our skeleton at paragraph 20
Your skeleton for the appeal.
for the appeal model? Yes.
Paragraph 20.
Yes, which is in internal page 5. So at 18 we deal with the offers,
Yeah.
and then at 20 we say both at the 15th of April and at the 21st of April the sum actually due to the first respondent was less than 1.85 million. And then if you turn over to page 10 internally, paragraph 44. We say that the offer should, as it turned out, have been accepted, and their refusal to do so should disentitle from claiming interest for the period following the date when the ban would have been, when the loan would have been redeemed. So, my lord, I think what I said this morning was consistent with that. At least I hope it was.
Yeah.
And then the other point was the point that your lordship left me with just before the short adjournment in relation to the Chukarova jurisdiction, and in particular the result in Chukarova. I think our position is this, that it is an equitable jurisdiction, and equity has a wide discretion in terms of the way in which it presents a remedy to a person who is deemed to be worthy of that. Therefore, on the facts of the case of Chukarova, one could well see that that was the fair and equitable result in that case. As I said, when your lordship asked me about it first thing, about the halfway house idea, I think what we say is it would be open to your lordship to arrive at a halfway house, but that it is difficult to see on the facts of our case how you arrive equitably at a halfway house because of what we say. It would be wrong, we say, for your lordship to say, for instance, well, you get no interest until such times as the default at the end of the period, and then you get default interest or whatever interest is set to run at that point as a halfway house. We say because of the nature of the inequity in this case, because of it all stems from the events of the 29th of July 2020, it's hard to see why they should, if you're satisfied that they have prevented the Husseins from paying back the loan, it's hard to see why in those circumstances they should get anything for the period post the end of year one as a halfway house.
Well, it means that the Husseins have the use of LCL's money for nothing.
They do,
After that date.
well, they do, that's right, but only if equity intervenes to assist the Husseins, and on the basis that they have prevented them from paying back the very money that they have the use of.
Yeah.
Well, just to finish off on Chukarova, I was going to take your lordships briefly to the authorities between paragraphs 30 and 35.
Yes.
Because this is what then guides the statement of principle at paragraph 42. So the court says, seventhly, if it's of some interest to look at equity's response to tenders or offers of repayment which are refused or do not, for other reasons involving the lender's fault, lead to actual repayment. In a number of such cases, the court has held on equitable rather than legal grounds that the mortgagee was as a result relieved, the mortgagor was as a result relieved of any obligation to pay interest. And it starts with Manning and Burgess in the 17th century. And it is right to say that that is a case where the mortgage had been redeemed. And we see that from the first line of 31. After a mortgage was forfeited, mortgagor had stated his willingness to come and redeem. But one then moves to Webb and Cross at paragraph 32.
Sorry, just
Sorry.
what does it mean a mortgage was forfeited? What does that mean?
Well, my reading of that was that the mortgage was brought to an end by foreclosing.
I don't know. Is that what it means? It may do.
Well, that
may
that's
just
my,
mean the legal
yes.
date for repayment passed. I'm not quite sure what it means.
Well, yes. Well, I'm not sure I can help. I certainly took it to mean that the
Perhaps Mr.
the
Blake
mortgage was
can
brought
have
to
a
an
look
end.
at it overnight and see if we can work
Yes,
out what
well,
it actually means.
Right, that would be a good idea. Well, we'll do that. The point I make about that is even if my assumption is right, that this was a case which falls into the category of the contract having, the debt having been resolved and gone away, in none of the other cases between paragraphs 32 and 35 does that seem to be the case. They all seem to be cases where the contract was continuing, and as per this case, there was simply an offer to redeem which was then rejected. At paragraph 35, the conclusion then is that these authorities show that equity will consider whether the mortgagee by his conduct or fault may have disentitled himself from insisting on the usual conditions on which equity insists for redemption. So in other words, redemption hasn't happened yet. And then he cites the various authorities on the other side, through to paragraph 40. And then he has a paragraph at 41 dealing with costs, and that's what then leads on to, so the reference in the second line of 42 to the 7th and 8th points above. So the 7th point is where he's considering specifically the series of authorities to which I've, on both sides, to which I've just taken your lordships. And that's where he then says equity can and should respond by a special order as to interest in exceptional situations where the mortgagee has by words or conduct.
Yeah.
It's only right that I take you to paragraph 44. Where the board emphasises that it's not suggesting that equity recognises an open-ended discretion. The board's reasoning and decision in this case are based on confined to what it sees as an exceptional situation. And I've already made my submissions as to why we say this is an exceptional case as well, in which equity ought to intervene. So, my lords, that's all I wanted to say for the time being about ground 2.
Would it necessarily be unlikely that a mortgagee would claim more than he's actually entitled to? Maybe this particular claim is exceptional, but
yes,
mortgagees claiming more than they're entitled to wouldn't be that exceptional.
Well, I think it goes further than simply them claiming more than they're entitled to because, for instance, they've miscalculated or done something wrong with the maths that means that there's a genuine belief on their part that they're entitled to those sums. As I've already indicated, in this case, they are fixed with the knowledge that the Husseins were there and that therefore there was no breach. And having been fixed with that knowledge, they nonetheless claimed default interest, which in my submission is somewhat different from simply someone saying, I've claimed too much. So then in relation to ground 3, obviously if the court is with us in relation to either grounds 1 or ground 2, then ground 3 becomes irrelevant and falls away. As we say in our skeleton, we don't take exception to the judge's exposition of the law. The principles are those set out in the Cavendish Square Holdings and L. McDessie case. We don't specifically seek to criticise the judge for seeking to separate out, which he failed to do in his first judgment, the various legitimate commercial interests in performance which LCL would have. Instead, we say this ground is based on the manner in which the learned judge applied the law to the facts. We've referred to a number of points in the skeleton. We pursue all the points that are in the skeleton, but I want to focus my oral submissions on the legitimate interest that the judge spent by far and away the most time dealing with, which was the credit risk interest. Can I take you then to the judge's judgment, which is in the core bundle. Starting at page 82.
82?
It starts at page 82, but can I take you to paragraph 169? So that's
Yes, I thought 169, but where's 82 come from?
sorry, my lord.
Internal page 44, bundle page 125.
Yes, no, the judgment starts at page 82.
Oh, I see, yes. The credit risk interest starts at 169, yeah.
Yes, I'm grateful.
And what he means by that, legitimate interest in primary obligations that go to preserve a borrower's ability to repay the debt when due.
Yes. So each of the obligations to which he points within that paragraph goes to that interest. So in other words, if the borrower has difficulty in relation to its other financial affairs, then that, in a sense, is the legitimate interest on the credit risk interest, because it has a bearing on the extent to which they will then be able to repay the debt at the end of the term. Now, the first and perhaps the most important point that we make, and we do say that the judge fell into error in the way in which he dealt with this, and I'll come back to that in the course of my submissions in due course. But the first and most important point to note is that what the judge says about the credit risk interest in his judgment, and there's quite a lengthy passage in which he deals with it, was not only not argued by either side, but was not raised by the judge at any time prior to his giving judgment. He did not, for instance, say to the parties either during the course of argument or subsequent to the argument that this was a line that he was considering pursuing in the course of his judgment and inviting the parties for their comments upon it.
So this ground is essentially procedural irregularity causing
yes.
substantial injustice.
Well, yes.
Which would lead to the conclusion that the issue should be remitted for a redetermination.
Yes, well, my lord, that's an interesting question to which I'll come on.
Well, that's the normal remedy for procedural unfairness.
Yes.
To give the afflicted party a procedurally fair hearing.
Yes. Well, we say that really there are two options open to the court. One would be the usual remission, as your lordship rightly points out. I think part of the reason that we're slightly hesitant about that is that obviously it's been remitted once already, and this would be the third trial, which is why we say that we slightly favour the alternative, which is that this court simply substitutes its own view for that of the trial judge, because at least then we have an element of certainty as to what the position is and an element of finality to the proceedings. The downside, obviously, in relation to that is that your lordships have not seen the evidence, your lordships have not heard all the argument in relation to that evidence. So there are pros and cons on either side, but I accept my lord's point that the usual order would be to remit the matter back to the trial judge.
I'm not sure deciding it is something that is open to us. There's a Supreme Court case called Serafin and Malkovich, I think it's called, which says that if a trial is unfair, that it's got to be retried. The appeal court can't try and salvage bits of it.
Yes, well, I'll need to look at that authority, my lord, but if that's right, then it may be that remitting it is the only answer that's open to the court. Secondly, my lord, we say that the judge's conclusions are in any event specifically contrary to the evidence of the appellant's expert, Mr. Griffiths, whose evidence the judge otherwise accepted or preferred to the evidence of the respondent's expert. And we say that there's nothing wrong with the judge making a determination which is contrary to the views of the expert. But we say that to reach that conclusion, contrary to the express views we say of the expert, even though it's not advanced by either party, and where the expert is not given any further opportunity to comment upon the fact that the judge is disagreeing with his evidence, is, we say, a procedural irregularity. Can I then take you forward in the judgment?
Which would lead to the same result.
Yes, my lord. Yes, and if your lordship is, and you, my lord, if assuming that your lordship is right, which I do about that case, then yes, then we would be looking at remitting there would be a question about whether it should be remitted perhaps to the same judge.
Well, that's a different question. I can see why it might not be.
Yes. My lord, can I take you forward in the learned judge's judgment to paragraph 305?
Just before we go there, as I understand it, neither expert was recalled for the remitted hearing. They were both called and both cross-examined at the first trial.
That's right. Yes.
Was there any reason why they weren't recalled?
Because because neither side ran the argument in the way in which the judge eventually decided the case. But both sides were content to rely upon the evidence which had been given at the first trial to argue whether or not the default rate was a penalty. And it's easy with hindsight, but one of the things that we would certainly say is that had the judge made it clear to us that this line of reasoning was his thinking, and in particular his use of Mr. Griffith's evidence to arrive at the conclusion that he arrived at, we would have recalled Mr. Griffiths to give evidence.
Can I just be clear
Yes.
as to the nature of the remittal in this case? Because when you have an issue being remitted, I mean, simplifying somewhat, there are two basic models. One model is for, in effect, a de novo trial of whatever is remitted. So you have fresh evidence, fresh argument, and it's as if what happened before had never happened, so far as the remitted issue
Yes.
is concerned.
Yes.
The other model is you've already got all the evidence, you take that evidence as it stands, and it's simply a question of further argument based on the existing record.
Yes.
Now, the impression I'm getting from what you've told us already is that the latter applied in this case.
The latter applied in this case at the remitted hearing that we had back in September of last year.
Right. And I'm not doubting that, but can you just explain to me how we know that?
Because, my lord, neither of the experts was called to give evidence afresh. So as
But that might have been because nobody thought about it. In other words, sorry, let me be more precise as the question I'm asking for you.
yes,
Were the ground rules for the remitted hearing set out in a way that we can find easily accessible to us?
there were
In other words, was there a directions hearing or were there agreed directions which set out the ground rules so that everybody knew what was going to happen at the hearing?
yes, my lord, there were directions. I think the directions are in the bundle. They are at, is that supplemental? So they're not in these. No. Oh, I'm being told that they're not in these bundles, but there were directions.
Right.
There
So,
was
and that
a
will have
set
provided.
order.
So did those directions say all the evidence given at the previous trial is in, no further evidence, that kind of thing?
In effect, it did.
Except there was some further evidence, wasn't there?
There was, because, so paragraph 5 of the directions order was, the parties adduce and serve evidence if so advised only in relation to new matters raised in the counterclaim and defence to counterclaim, not already covered in the pre-existing trial witness statements.
That's
So there
the
were-
tender argument.
So that was the tender argument. So there were witnesses, as your lordships have already seen. Rose Houssein, for instance, gave evidence at the remitted trial for the first time.
Well,
but there was no further expert evidence, and there is nothing in the directions order about expert evidence, because I think both sides took the view that they were content to rely upon the expert evidence which had been given at the first trial.
so I'm just looking at the judge's discussion of what has been remitted, starting at paragraph 130. And he recalls that there's disagreement about what was remitted.
Yes.
Mr. Wheeler says the task is limited, the Court of Appeal had identified the relevant legitimate interest, and you say, see para 132, you needed to do a broader re-evaluation,
Yes.
and you then say it's not solely by reference to interest in repayment. If it was extortionate or unconscionable legitimate interest underpinning any primary obligation, it could be unenforceable. And then at 133, this he submitted put everything back in play. I'm not quite sure what that was supposed to mean, but
Well, I think what it certainly didn't mean by that stage was that it was open to the parties to adduce further expert evidence on the question of penalty, because that had been effectively determined at the directions hearing prior to that.
but
This was a point.
You are inviting the judge in 132 to look at legitimate interests underpinning all primary obligations, aren't you? Whereas Mr. Wheeler is saying, no, it's only by reference to repayment.
Yes. Yes.
And by reference to all legitimate interests was not something that Mr. Griffith had previously addressed in his report. In fact, neither expert had addressed it in that rather methodical way that the judge adopted.
Yes, neither of them specifically separated out the legitimate interests and went through them one by one to determine.
But yet that's what you're inviting the judge to do, on the basis, presumably, of the evidence that had already been given.
Yes. Well, that's correct.
So it's just inherent in that invitation, isn't it, that things might come up in the course of that broader re-evaluation that hadn't been covered in the first trial. What was the judge to do?
Well, the judge would normally do what judges normally do, which is to say, I've considered this question of credit risk.
You need to recall Mr. Griffiths.
Not necessarily, but simply to say to the parties, this is my line of thinking in relation to this. Neither of you has argued this point. This is my line of thinking in relation to it. Do you have any comment about it? At which point our comment would have been absolutely, because you're going against specifically what our expert said in his evidence at the first trial. Therefore, we'd like to give him an opportunity to comment on your reasoning. Well, I think I was going to take you next to
305.
305, which is simply where the discussion picks up about the credit risk interest. And then at 309, he makes the point that the third appellant's credit risk would be somewhat further impaired. Claimants would now have something of a record of such judgments being rendered against. This is county court judgments. Since this remained a risk rather than a cause of payment default, in principle, one might expect an impact of a similar order of magnitude, 0.3 to 0.5% per month. So the point he's making there is that there had been a credit risk analysis of the Housseins and the company at the time that the facility was entered into. We know that because that was in evidence at the first trial. And the evidence that was given was that in fact the 1% per calendar month was an increase of 0.3% over the standard rate to take into account the fact that there was a county court, or more than one county court judgment, I think it was, against the Husseins. So the judge is saying here in paragraph 309 that the default rate that applies, this is at the top of the next page, the default rate that applies when a £20,000 judgment is rendered and left unpaid for a short period during the term of the loan is very significantly more than the increase to the standard rate, reflecting an almost identical judgment rendered before the date of the facility letter. In other words, how do you square the fact that you've got a county court judgment for £15,000 and you increase the standard rate by 0.3% to take that into account, but the minute you have a £20,000 county court judgment which is outstanding for more than 3 days, you're all of a sudden up to 4% per calendar month. And he says at 310, no explanation for this difference in treatment was offered by LCL. And he says that that's not to say that if the witness and his colleagues at LCL had given their reasons, he would simply have accepted them. And then at 311, he says that the point, it seemed to me, was that a key risk identified in connection with historic payment defaults was a risk of future payment defaults under the loan. Historic payment defaults, most notably the county court judgment, were addressed by a relatively small rise in the standard rate. By contrast, an almost identical default was addressed by a much greater increase, nor could this be dismissed on the basis that the historic default was years in the past. Had that been the case, then objectively, I can see it would limit the predictive force in the past event. Here, however, the county court judgment was only around a year in the past. And then he makes a point about the personal guarantees and the charges of the properties and the default being well guarded against. And he says that he considered that a further 3% increase linked to the risk of default payment was objectively assessed extortionate. And then at 313, he says in that he was wrong. So what we say about that is that that's the judge's starting point, and his starting point, we say quite rightly, is to focus on the fact that having increased the standard rate of interest by 0.3% to take into account the county court judgment against Mr. Houssein, he asks why should it be the case that the risk of defaulting by having a third party county court judgment for more than £20,000, a very similar risk, should attract a default rate which is 10 times as great as that of the increase. And then at 316, he comes to Mr. Griffith's evidence, and he says that Mr. Griffiths explained that in assessing the viability of the exit strategy, the lender would have two issues at the forefront of its thinking: the LTV, the loan to value rate, and the interest cover. Could the rental income support the interest payments, since the replacement lender would only be prepared to fund the refinance if the interest on its loan could be paid? And he says both were critical. And then he quotes from paragraph 357 of Mr. Griffith's evidence. And then at 318, he then introduces into his reasoning a document, this is the line 2 of 318, a document that I understand was in LCL's disclosure, showed that LCL had assumed that any lender refinancing the loan would charge interest at 5.5% and would want rental income to be 145% of that amount to be comfortable that the interest could be paid. Now that document is in fact a document which Mr. Griffiths then comments on in his expert evidence at some length. And can I pause with the judgment at that point and take you to the evidence, which is in the supplemental bundle. At page 95 of the supplemental bundle. So the way in which Mr. Griffith set out his evidence was he set out the questions that he was asked by those instructing me when he was instructed. And those are the bold part of the expert report. So he's asked, look at the entry on page 5 of the disclosed underwriting checklist, which reads, and then there's the formula, and then we suspect this represents an affordability calculation of the minimum rental cover required to support a loan of 1845. Can you explain the calculation, break it down into its constituent parts? So first he explains at paragraph 355 what the document is. It's a hypothetical calculation to show whether the rental income from the properties would serve as a conventional buy-to-let mortgage with a lender offering longer-term loan facilities. He says that the process is described in paragraphs 359 and 384 to 385 of LCL's Underwriting Procedures Manual. Calculation is also referred in the underwriting checklist dated 2nd of July 2020. So this is a document which had come from LCL and which at least partially explains LCL's thinking in terms of how it was going to assess credit risk, the credit risk interest, which is relevant, we submit, to the question of whether or not the rate that it fixed then for that type of default of 4% per calendar month was excessive or extortionate. Then at 359, just skipping forward a couple of paragraphs, he explains the calculation. So this takes the rather abstruse formula and breaks it down. So 1845 is the loan amount, and you'll recall that that was originally going to be the loan amount, which was then changed to 1881 by a deed of variation subsequently. Interest rate of 5.5%.
5% what? Per annum? Per month?
Per annum. Because then in line 3, it's the annual interest, is line 1 times line 2. So then you say, you bump that up by 45% to get your adequate cover to 145%. So you go from 101,000 to 147,000. And then you take a monthly figure, which is simply that figure divided by 12, coming out at £12,261 per month. And then line 6 is the actual market rent of the properties, which he takes as £145,000 per annum. So the monthly rent based on the actual market rent is £12,083. He makes the point at 3.63, 4 paragraphs below, that in fact there is a shortfall there. So there is a discrepancy between the monthly figures shown in line 5 and line 7. But as he points out, the 12,083 difference still provides cover of 142.9%, which he says would be sufficient to satisfy most buy-to-let lenders. So he's not troubled by the slight shortfall. Now at paragraph 366, he confirms that this calculation included the market rent value of 71 Hamilton Road, which was £33,600. And I'll come back to this, but it's important to note that in his judgment, the learned judge assumes the opposite. He assumes that there is no income to be taken into account from 71 Hamilton Road.
But there wasn't any income. The Husseins were living there.
Well, the Husseins were living there. That is right. But nonetheless, the important point is that LCL, when it came to determine what the appropriate rate of interest was to protect its credit risk interest, it did take it into account, rightly or wrongly, probably wrongly, but it did take it into account. And therefore, if the question that the judge had to determine was whether or not the 4% per calendar month is an extravagant or extortionate rate to protect that credit risk interest, the judge should have been looking at what LCL actually did. I mean, he says in his judgment that there was no evidence from LCL about what they did. Well, in fact, there was evidence about what they did. And we also know from the first trial that the 4% was set simply across the board without reference to the individual borrower. So we do have, and the judge did have, some information, and a very important part of that information was, rightly or wrongly, that LCL had taken into account the notional rental value of 71 Hamilton Road. And this is what then leads to the table at 367. And you've got a table representing 125% interest cover up to 140% interest cover. The judge is quite right to say he doesn't do 145% for some reason, but he does say earlier on at paragraph 364 that the majority were in the bracket 125 to 145, and that 145 is at the upper end of the range that could be used, can be regarded almost as a worst case. So that might explain why he then uses 125 to 140. So the top part of that table represents the interest cover at these various levels of comfort, as it were, assuming that 71 Hamilton Road had an income, which is what LCL actually assumed. What he then does is to strip out the LCL income, and so the bottom half of the table is simply the income on the Downhills Road properties.
Just to be clear, I mean, this doesn't go to anything at all, but I see in the table I set out in the judgment, the figure, the rental income for the Downhills properties is slightly out.
Yes, there was I think he acknowledges in the judgment that there was a slight error in Mr. Griffith's
Oh, I see. So the
figures.
I haven't been paying enough attention. So when it says in the judgment 114 400, that's
what
right.
it should be.
Yes.
Yes.
Okay.
Yes. And the figures in the bottom row of each of those halves of the table are then compared with the figure at paragraph 368. And just to explain what 368 does, so he takes the whole of the loan amount of 1.881 million. He deducts 12% interest, so that's 1% per calendar month. And he deducts 2% of the fees payable for the loan. And the result, and he does that because earlier on in his evidence he said that the 4% fees that were being charged to the Husseins was very high and was not normal. It would usually be around 2%. And he says the resulting debt is 1,618,380. And then what he says is that the rental income of 111,400 could not fund interest on this level of loan at 1% per month, but easily could if the rate was 0.6% per month for a 9-month loan rather than 12 months. But one goes back to the top part of the table where the Hamilton Road income is included, you'll see that the figures are all significantly above the 1,618 figure that the judge then took from Mr. Griffith's evidence, and indeed even if you extend the table to the right and put in 145%, actually it's quite an easy calculation, because that means that the interest cost is exactly 100,000, which means that the maximum loan available at 5.5 is 100,000 times 18.18. That's in the footnote at the bottom of the table. So you come out at 1,818,000. So again, whichever of these you choose on the basis of the assumptions which LCL actually made, it is very comfortable. The learned judge then does three things in his judgment where we say he falls into error. The first is the point that I've already hinted at, which is that he says that LCL should only have taken into account income on the Downhills Road properties. That is at paragraph 324 of his judgment. He says that LCL had been told that 71 Hamilton Road was still undergoing renovation work, and that following which the Husseins were to move back in. Of course, first of all, that's not the way on which LCL actually did the calculation. We know that from the underwriting sheet. And had they then changed their minds as a result of that, we would have expected in disclosure to have seen something where different figures were advanced, but there was no such disclosure. That was the only disclosure we had. That was the basis on which they arrived at their 4% default rate. So we say that the judge fell into error by using some hindsight, as it were, to put himself squarely within the bottom part of the table, which in fact was not what LCL had assumed, rather than the top part of Mr. Griffith's table, which is what LCL did assume, and which showed a very comfortable situation at whichever rate was used. That made it easier for him to conclude that there was a significant risk that the properties would not be able to be refinanced based on his other assumptions, to which I'll come. And therefore he made it much easier for himself to reach, we say, the wrong conclusion. Now at paragraph 327, in the context of loan to value rates, slightly different point, but in that context, he says, 5 lines down, I also accept that if the property was not let, he's here talking about 71 Hamilton Road, if the property was not let, it would not be producing income, but I attach no real weight to that point, he says. But actually he attaches a huge amount of weight to that point, we say. Because if you, again, go back and compare the figures in the upper part of the table, all of which are very comfortable in terms of a total debt of 1.683 million, and compare them to the, 1.618 million, compare them to the figures at the bottom part of the table, it makes a huge difference. So he doesn't, in my respectful submission, attach no weight to it. He attaches quite considerable weight to it. And what he says is that when you look at only the Downhills Road properties, the only way in which this keeps its head above water, as it were, is if the interest cover is 125%. So if you have any lender who is saying, well, that's not good enough for me, I need more protection, then he's effectively saying you're already in a position where you're not going to be able to refinance, but it's based on, we say, the wrong assumption. Then, my lords, the second error that we say he fell into is at paragraph 325, where he quotes from the evidence of Mr. Theophanus at the remitted hearing. And what he says, sorry, beg your pardon, let me just find it. Yes, at 325, right at the beginning, he says, matters in my view changed at this hearing. So he's here talking about loan to value. He says the effect of the Husseins remaining in 71 Hamilton Road on the loan to value became clearer, certainly to me. It was put to Mr. Theophanus in the context of the settlement negotiations that he was unreasonable to refuse an offer where outstanding sums were secured by a charge over 71 Hamilton Road. Mr. Theophanus did not accept this. And you'll see the questions and the answers from Mr. Theophanus. And the judge's conclusion from that was that that changed the picture, the position in relation to loan to value, and that therefore that again bolstered the idea that a higher default rate could be set in relation to the credit risk interest. We say the judge fell into error because it's quite clear from the questions that were being asked. Indeed, the judge says this in the third line of 325. The questioning was not questioning about loan to value. It was questioning about the settlement negotiations or settlement negotiations and why it was unreasonable to refuse an offer where sums were secured by a charge over 71 Hamilton Road. That's a very different proposition, we say, from deducing from those answers a point about including 71 Hamilton Road within the loan to value calculations. And then we say the third error is that the learned judge then used subsequent events to colour his view of the extent to which the properties would be refinanceable by a new lender coming in, which after all is the point of this. So he makes the point quite rightly that in looking at whether or not a rate of interest, a default rate of interest is a penalty, it is a question of construction to be considered at the time that the facility is entered into. You don't look at later events with hindsight. Indeed, that's part of his criticisms of some of the other authorities, was that they were looking at credit risk from the point of view of credit risk which had already made itself plain, as it were, because there had been default, rather than credit risk, forward-facing credit risk, which was what he says was important in this case. So notwithstanding that he then says that, what he then does at paragraph 329 is to take into account the fact that in 2023, Kent Reliance declined an application for refinancing of 205 Downhills Way because the property was being used as a house in multiple occupation and being used for assisted living tenants. And then he makes the point that at 330, that would inevitably call into question the exit strategy, because it seems likely that other less flexible lenders would take the same view. To be clear, I recognise that earlier applications on 205 had been approved at the levels sought. The point is that LCL had no control over how the claimants let the Downhills Way properties or to whom. Yet a shift in these factors at any time during the term of the loans could prejudice the refinancing. Now, we accept that as at the time that the facility is entered into, any of these things that actually happened subsequently could have happened and therefore were part of the, or at least theoretically could be part of the credit risk interest, which then goes to the question of whether or not the 4% is extortionate or excessive. But what the judge doesn't do at any point in his judgment is to assess the likelihood of those things happening from the standpoint of July 2020, when the facility is entered into. On the contrary, he simply rehearses the fact, for instance, that in 2023 Kent Reliance declined because it was an HMO, and then applies that knowledge, we say, doing exactly the thing that he said he wasn't supposed to do, namely to look at a backward-facing default rather than the forward-facing credit risk. So we accept, for the purposes of our argument, that yes, those things could have happened. And if they could have happened, then the question is, well, how likely was it in July 2020 that they were going to happen? Because the more likely they are, the easier it is to then be able to say, well, then 4% is a perfectly reasonable default rate because you've got more reason to want to protect your interest in that way.
Was there any evidence?
Well, there wasn't any evidence about that. There's certainly no evidence in Mr. Griffith's evidence, and of course, again, there was no evidence about there was no evidence dealing specifically with this approach to the answer that the judge adopted because we didn't know anything about it. He literally doesn't refer to this. It didn't refer to it in argument, didn't refer to it when we were closing the case, comes up with it for the first time in his judgment, which again, I'll come back to that. So, Lords, we say it's the combination of those three errors, the most egregious of which is that he assumed that there would be no income from relating to 71 Hamilton Road, which may have been right factually, but wasn't the assumption that LCL made when it fixed the default rate. But the combination of those three, oh sorry, I've missed one out, I beg your pardon. The other part B, as it were, of the third error is that at paragraph 332, he also relies upon an increase in the Bank of England base rate from 0.1% in July 2021 to 5% in July 2023. And he says it's still on an upward trajectory. And again, we make the same point again. That was always a possibility. So you would build that into your credit risk interest decision. But the judge doesn't at any stage in his judgment say, well, what was the risk of that happening in 2020? To what extent can that explain why it's 4% rather than some other figure? So we say it's the combination of these errors which then lead the judge to conclude that a high default rate was justified in protecting LCL from the possibility that no refinancing would be available. And at paragraph 338, this is where he makes this point. It explains why the credit risk interest would be so critical to a lender in LCL's position. It's not simply that a £20,000 judgment debt would mean the claimant's total debt would increase by that amount, which is only 1% of the loan. If the claimants further defaulted or faced further credit issues in respect of other obligations, there's a material risk that the assumed interest rate they could face on refinance would increase, just as the standard rate they had to pay to LCL had increased. That in turn would affect the interest cover ratio, and the consequence could be anything from a reduction in the loan amount, which in itself could be terminal for refinancing, to some or all of the investment properties not being capable of supporting lending at all, which obviously would be terminal. And at 339, he makes the point that a lender in LCL's position in July 2020 would properly conclude that there was no or almost no margin for error. That, my lord, is why the the 71 Hamilton Road assumption is so important, because the minute you look at the top half of the table, there is an enormous, well, not an enormous amount, but there is ample room for error. And that then leads him to the conclusions at 345 and 347 that the 4%, whilst high, is not excessive or extortionate. And I come back to where I began, which is to say that the errors that the judge made wouldn't be so egregious if he had at any stage said, this is the way I'm thinking, could you comment on it? Because then at least we would have been given the opportunity to comment and at least decide whether or not we wanted to call Mr. Griffiths back to explain that element of his evidence.
That's the bit I'm not following at the moment.
Yes, my lord.
So you identify 3 errors that you say the judge has made.
Yes.
But why are you not simply right or wrong about that? I don't quite follow the nexus between the errors in the reasoning which you complain about and the procedural unfairness which you complain about. They seem to be independent.
Well, my lord, yes, I see your lordship's point. I suppose we could simply have included as grounds of appeal that he got those things wrong. Yes, I think that's a possibility, and I can see your lordship's point that they are separate. I think the point on which we focus the most attention, however, is the fact that having reached those conclusions, whether they are right or wrong, he didn't give us the opportunity to comment on them and to deal with them properly, and we say that did lead to substantial injustice, because it meant that his decision was that the 4% per calendar month was not a penalty, whereas we maintain that it is, and therefore.
But you see, this is why I'm struggling, because I'm not expressing any view at all at the moment as to the correctness. But suppose we accept that the judge's analysis is vitiated by those 3 errors that you contend for.
Yes.
Then why does it not follow, as you've just said, that he was wrong to conclude that it wasn't a penalty? At which point the alleged procedural unfairness simply drops out of the analysis.
Yes. Well, I do take on board your lordship's point, and maybe that we could have advanced the case in that way. Whether or not it needs to be borne in mind that this was only part of his analysis. So we do say that he made these errors in coming to the conclusion that he came to. I've taken you obviously only to the passages on which I particularly rely from his judgment. It was a process which he spent a very long time talking about in his judgment, and there are parts of it which we don't criticise. Now, that is not to say that I'm suggesting that overall he got the answer right. Overall, I think we say he got the answer wrong, and I do take on board your lordship's point that if the court is satisfied that he simply got it wrong, then again one comes back to the question of remittal, or the court substituting its own decision for his decision. If your lordship is right, and as I say, I take on board your lordship's point completely, that actually what we're saying is he got it wrong, then, and we're not relying on the procedural irregularity, then that gives your lordships an avenue to substitute your lordship's decision for that of the trial judge.
Yeah. Can I just ask you about the error you say the judge made in relation to the letting, or the refusal in 2023 to let on one of the property, to lend on one of the properties,
Yes.
because it was being used as an HMO.
Yes.
And you said, well, yes, that's certainly a theoretical possibility that it might happen during the term of the
Yes.
loan because there was no LCL had no control over how the downhill properties were let.
It was only a 1 year loan. Don't forget
Yeah.
as well.
But you say the judge should have assessed the likelihood of that happening.
Yes.
How would Mr. Griffiths have helped on that question? How would his expertise evaluate the likelihood of a letting of a property on as an HMO?
Well, I'm not sure he would be able to. He clearly wouldn't be able to give evidence about specifically about how likely it was that the property would be used as an HMO. That would be a matter for the Husseins. But what he would be able to do would be to give evidence of the way in which mortgage lenders in the market would treat that risk. In other words, whether or not that was a risk that a mortgage lender a hypothetical mortgage lender in the marketplace would look at, the possibility within a 12-month loan that one of the properties would start to be used as an HMO, how serious that would be in terms of the risk, and therefore the extent to which that risk then has to be protected by a high default rate. But I take on board the point that your lordship is driving at. He wouldn't be able to say that likelihood. But again, if we had known that this was coming, then the Husseins could have given evidence about that issue. Well, the other point I make about that is that the court will also bear in mind that the judge accepted Mr. Griffiths' evidence at the first trial, preferred Mr. Griffiths' evidence to that of the respondent's expert. So it's all the more it's all the more unusual, we say, that at this point in his latest judgment, he should, as it were, go against specifically what Mr. Griffiths said in the course of his evidence.
But I'm not sure that you've shown us anything that Mr. Griffiths said that the judge went against.
Well,
you've pointed out the Hamilton Road. That does seem to be possible.
Yes.
That the judge says, you say the judge was looking at the bottom half of the table and he should have been looking at the top half of the
Yes.
table. That might be said to be against Mr. Griffiths' evidence. But the other matters you pointed to are not things that Mr. Griffiths ever commented on, are they?
Mr. Griffiths, I think I just look briefly at our skeleton. Try and set this out. Yes, I think it's the point that we make at page 19 of the skeleton, the final subparagraph 56.324. The rental income could easily could fund a new loan at an interest rate of 0.67 per month. So that I think is the point that I had in mind. Well, the other point is the correlation which we've made in this kind of argument, the correlation between the credit risk interest and the loan to value rate. Now, I took your lordships to the passage in the learned judge's judgment in which he said that Mr. Griffiths had said that both were crucial. And what the learned judge doesn't do at any stage, and both are to do with risk. So if you have a low loan to value rate, that is a riskier proposition than if you have lots of equity in the property, which enables you to ensure that you can sell the property and get your money back. And the credit risk interest we've discussed at some length is also to do with risk. What the learned judge doesn't do at any stage in his judgment is any type of assessment as to how the two correlate. So what he's saying is the credit risk interest in this case becomes very, very risky the minute you start moving the figures around in a way which could happen. But what he doesn't then say is, well, to what extent is that mitigated by the fact that in this case the loan to value rate was always very low and therefore it was a far smaller risk. And again, that's exactly the kind of evidence that we would have wanted Mr. Griffiths to come and talk about.
But can you explain that to me? I'm not getting that point.
Yes, my lord.
Because Mr. Griffiths did talk about that. He pointed us to the passage
yes.
where he addresses that question.
But he talks about that in the sense that he talks about both the credit interest ratio and he talks about the loan to value. But what Mr. Griffiths, what the learned judge says is, well, given the possibility of things changing during the course of the term, which would make refinancing by a new lender significantly more difficult stroke impossible, that means that LCL were justified in charging the 4% default rate. And what I say is, maybe, that may be right, but it may not be right, because what you need to do is to look at that increased risk in the context of the overall risk, part of which is loan to value.
Sorry, I'm still struggling to see what Mr. Griffiths has been deprived of the opportunity of saying. I mean, just by a random example, 3.75. Mr. Griffiths says, bearing in mind the LTV of the loan was 54.1%, I would expect that a relatively low interest rate would apply.
Exactly.
So
yes.
why is he not expressly addressing the point?
Because he's not expressly addressing the correlation between the loan to value rate on the one hand and the interest ratio, the interest cover ratio on the other hand. If you have an interest cover ratio which is marginal, to use the word that the learned judge used, in other words, when you do the calculation that Mr. Griffiths does in his table and you come out at a figure where there's either just about enough income coming in from letting the properties to support the refinance, or your...
Well, I'm sorry to interrupt, but I think we're at cross purposes here, so let me try and clarify my question.
Sorry, my lord.
No, it may be my fault for not making my question clear enough. I mean, at the moment, obviously I haven't heard what Mr. Reed has got to say, but at the moment it seems to me to be pretty plain that what Mr. Griffiths is saying in his report is if you've got a low LTV, then you need less interest cover, and vice versa. And so the point again seems to be not so much one of procedural unfairness, because gosh, poor Mr. Griffiths was deprived of the opportunity of commenting on this.
Yes.
It's more, you say that the judge's analysis is wrong. Again, I'm not expressing a view, I'm trying to analyse
I
the
understand
nature of your argument.
I mean, what can I just take you back to Mr. Griffiths' evidence then briefly? Because in the part of his evidence where he's discussing this calculation that LCL did, your lordship is quite right to say that he refers to LTV. So at 3.70 at supplemental bundle page 98. So he's done the exercise on interest cover. And then he says, by way of cross-check with the LTV, the market values of the Downhills Wave properties totaled 2.6 million. This gives an LTV range of 55 to 62%, which in my opinion would have been within the LTV criteria of the majority of lenders. And then at 372, he talks about the aggregate value of all the properties, so he's now including 71 Hamilton Road. Cross-checking this against the LTV for all of the properties gives a range of 54 to 60. But he's not at that point in his evidence, or at least my reading of his evidence, is that he's not at that point in his evidence saying that if credit ratio, if income ratio becomes much higher, then you don't need as good an LTV, and vice versa. He's simply saying there are these two different things. One is the income that you're receiving on the properties, the other is LTV, and they're both very important. But what he's not doing is saying how one affects, or how the perception of one affects the other as far as a lender is concerned. And that's the point really that I make.
Okay.
And then, my lord, finally on this, we say that in addition, the learned judge then didn't attach sufficient weight to what Mr. Griffiths had said in evidence in any event. So can I take you first to
Is this his use of the word penalty?
this is, my lord, it is his use of the word penalty.
Yeah. Well, the judge deals with that, doesn't he?
Does. The judge. So the judge deals with it at paragraph 286.
Yes.
So yes, perhaps look at 285 first.
Yeah.
He says the issue arose again in cross-examination. Having described 4% as very high, he observed that Mr. Kyriakou, that was the other expert, and I were really hovering around 3%. He then returned to the 4%. For it to be 4 times the contractual rate, to me, is excessive. And of course, the other point to make is that saying 4% a month is all well and good, but if you compound that, it becomes 60% per annum. It's a huge, huge penalty. And the judge explains this away by saying at 286 that the test for penalty had not been put to Mr. Griffiths at that stage. And he didn't take him to be saying that the legal standard was met. Lords, what we say about that is that it is unrealistic in a case where one of the issues was the 4% default rate a penalty, to use the word penalty without meaning penalty, particularly in the context of huge, huge penalty.
Well, can I understand that submission? Because I don't think the judge is saying that the evidence is inadmissible.
No.
What the judge is saying, as I understand it, is it's not determinative because the matter is one for the judge's assessment, not the witnesses. And what's wrong with that? It's a bit like, a witness comes to court and says this is negligent. Well, it's admissible, but it's not determinative.
No.
It's for the court to decide whether there's negligence or not.
No. I understand that. And the judge was at pains, I think, to make the point that Mr. Griffiths had said in his expert report that it was a matter for the court rather than a matter for him. This was him speaking, as it were, in the middle of cross-examination, where perhaps he wasn't as guarded about what he was saying. But he was asked to give evidence about the rate of default rates in the marketplace, and therefore his comment that for it to be 4 times the contractual rate is excessive, in my submission, was something that it was open to him to say, and in respect of which the judge...
But of course. So it's admissible evidence.
Yes.
But what then? Because if you accept, which I thought you did a moment ago, that it's not determinative,
Yes.
what's the judge done wrong by recording it and saying, well, I don't think this is determinative?
Well, my lord, we I think simply say that he should have attached more weight to it on the basis of the evidence that was given. He didn't attach
Well,
sufficient
you
weight
need
to
to
it.
read the cross-examination in context, I think. What is being put to him, see supplementary bundle, page 32,
Yes.
is something in the joint statement. The question he's being asked, what's being put to him, is you agree that a default weight of 4% would be more in line with the market as a maximum, but it could have been as low as 2%. And then he's taken to it, and then he says, Mr. Kuriaku and I were hovering around 3%. He goes on, and then he says the other point to make is that saying 4% a month's all well and good, but if you compounded it's 60%, it's a huge, huge penalty. So he's not being asked at that stage, does he think it's a penalty?
No, he's not.
He's asked on the next mini page, my manuscript page 142, line 60, line 14. It's accepted it's a high rate, and what he's asked is whether there's anything extravagant or unconscionable about it, and that's closer to the test of penalty. He doesn't answer that question. He answers a question about 5%. So that, as the judge says at 288, he doesn't give a direct answer when he's asked to apply the penalty test. His answer relates to an even higher rate than the one that's provided for in the facility agreement. That's his evidence.
Yes. Well, my lord, I'm not sure I can take that point terribly much further forward in the circumstances. Well, would your lordships like to hear me now on the point in the respondent's notice? Or shall I leave
It
that
might be
for
better
reply?
for Mr. Wheeler to open it
Yes,
before you reply to it.
yes, I'm grateful. Can I just take brief instructions? My learned junior reminds me that in Grand 3 of our Grands of Appeal, we do actually, this is a point in relation to my Lord Justice Arnold's point about the judge getting it wrong, that we do in fact say in Grand 3 that the judge got it wrong, as well as saying it was a procedural irregularity.
Right. Okay.
My Lord, I'm grateful.
Sorry, can I just read that? Be clear about the point?
Sorry, my Lord, yes.
Yes, that's
Fine. Your Lordship has it. Thank you.
Yes, Mr. Wheeler.
Well, I'm going to start off, if I may, with looking at the first and second grounds of appeal to some extent together, because they are both characterised, or both relate to the appellant's reliance on what the judge, in my submission, rightly characterised as the various offers of settlement that were made from March 2021 onwards, and which the appellants say ought to be characterised as tenders of repayment. Although my learned friend acknowledged, in fact, that his ground 2 perhaps comes before his ground 1, what I was going to do is start off with the law on tender, and then move on to the effect of the decision on Chukarova, and then build on to that, how the judge dealt with both of those points. And the appellant's case on this point, in my submission, is really quite a startling one. The loan was due to be paid in August 2021. Nothing at all has been repaid between then and now, nearly 5 years later, not even the capital, which is undisputably due. The appellants have had the benefit of LCL's money throughout that time. They've benefited from the rental income on the properties, which stand as security for that debt. And yet they say they should have the use of that money entirely interest-free, simply because their solicitors sent various letters in 2021 on which they proposed terms on which they would make repayment. The appellants never actually had the money to make the repayments that they were offering. And my learned friend rather skirted over the fact that there were occasions when LCL was seeking to accept what was under offer. My learned friend put it very starkly that LCL simply rejected these offers. But it's not as straightforward as that. LCL did try to accept payments in sums that the appellants had indicated that they were prepared to pay, and the appellants then didn't conclude a deal. Essentially, they say, by virtue only of making the offer and not having it immediately and unequivocally accepted, LCL then forfeits the right to interest. And that, in my submission, is an extraordinary proposition. It's one unsupported by authority, and it's one unsupported by principle. But just by way of a roadmap of the points I intend to make, I'm really going to advance 6 key propositions. The first is that a tender, in its very essence, is an attempt to discharge an outstanding debt by paying it, thwarted only by the creditor's refusal to accept the proffered payment. Secondly,
Don't go too fast.
no, sorry. Secondly, tender requires not merely a one-off attempt at payment, but the ongoing ability to discharge the debt. There is no basis on which tender can be relied upon by way of a defence, which also leaves the debt unpaid. Then thirdly, while I accept there is room for debate over some of the nuances on the requirements of tender, the headline requirements are beyond any real doubt. And I think, having heard my learned friend this morning, I'm not entirely sure they're particularly in dispute. They're really fourfold. Firstly, the tender must produce the money required to pay the debt in full. Secondly, the tender has to be essentially unconditional. The debtor can't attempt to renegotiate the contractual terms or impose new conditions. Thirdly, we see that tender and discharge are different. Tender by itself doesn't constitute a discharge of the debt. And then finally, for tender to stop the ongoing accrual of interest, the money tendered must be set aside and kept available to discharge the debt. The debtor can't keep the benefit of the creditor's money and at the same time stop paying interest on it. That, apologies, is my third, but most long-winded of my headline points. Coming back to the 6 headline points, the fourth is to submit that, having accepted that there is room for debate over the nuances of the law of tender, particularly in a modern context, those nuances do not matter in this case. This is not a case in which those nuances need to be determined by the court, because it's quite clear that the headline requirements are not met by any of the offers relied on by the appellants. As the judge found, they're not tenders, they're conditional offers of settlement. And my learned friend this morning was at pains to emphasise that his case was that interest ceases to run only from the point at which redemption would have occurred, which is, in all of these cases, a later date than the date on which the offers are made. But it is still the offers themselves that are relied upon as the tender. That's what's said to constitute the tender. Fifthly, turning to Chukarova, that is a case on relief from forfeiture. So the starting point is it's not directly relevant to this case at all. what it does do is reveal quite a complicated and difficult debate over whether the rules on tender are rules or simply aspects of a general equitable discretion. But again, that debate really doesn't matter to this case, because even if there is a general discretion to grant relief, it can be granted only on the basis of requiring performance of the contract. And then finally, even if I'm wrong about my reading of Chukarova, and even if there is a general equitable discretion to be exercised in exceptional circumstances, as my learned friend contends, the judge was entirely right that the circumstances of this case do not justify the exercise of such discretion. This is not a case of a debtor attempting to repay who was then frustrated by a difficult creditor. The judge found that LCL behaved reasonably in responding to the appellant's offers, and it's the appellant's conduct which was the subject of criticism. My learned friend glossed over that, but that was the finding that the judge made in very stark terms. And that makes it almost impossible to conclude that this is a case which, if there is an exceptional jurisdiction, it's appropriate to exercise it. Then, just by way of final preliminary point, before I go on to develop those propositions, I just want to address very briefly the use of the term offer, because it bedevils this case. And one sees it used by my learned friend in his skeleton argument in a variety of contexts. He refers to his the settlement proposals as offers, offers to repay the loan, offers amounting to valid tenders, and contractual offers. One sees different formulations, and the judge distinguished between the different uses of the word. And I just wanted to grapple with that at the outset to be clear on what I'm saying. There is, of course, first of all, an offer of money, which is simply another way of, it's effectively synonymous with tender, an offer in that sense. Attempt to hand over or transfer money to another party. Now, you accept that sort of offer by taking the money. That may have contractual consequences. It may discharge a contractual obligation. But it doesn't vary the terms of a contract or create a new contract or have any contractual consequence of that kind. You've then got an offer in the contractual sense, which potentially gives rise to a contract if accepted. In the background of an existing contract, an offer of that kind isn't a simple attempt at performance of an existing contractual obligation. It's a proposal that the contractual terms change. The parties should do something different from what was originally agreed. And that's essentially the sort of offer we see being made by the appellants. And then thirdly, the judge referred to invitations to treat, which is perhaps a form of offer in a looser sense. Obviously, that almost by definition doesn't have any legal consequences. The key distinction is the distinction between an offer in the first sense, in other words, a tender, and I will try to use the term tender rather than simply talking about an offer, and offers in the second and third senses, in other words, proposals of one kind or another to vary the contractual position between the parties.
Is it, I'm not sure it really matters, but is it quite as simple as that? You've, in your headline points, suggested that there's room for debate over some nuances related to tender. You'll expand on this further, but it may be that on that basis you're suggesting that you could have something that's good enough that doesn't absolutely precisely meet the terms of the obvious terms of the contract. Now, on that hypothesis, it would still be a tender, even though on this classification you might put it into your second category of something changing the contractual terms.
No, I think to be a tender, it would have to be attempting to discharge the existing contractual obligations.
I quite fully would be, perhaps this isn't the time to have this debate, or maybe the debate isn't needed at all, but if you're recognising there could be some nuance,
Yes.
maybe you're suggesting that there could be some scope for something along the lines of what Mr. Alexander had in mind.
Well, I think where the nuance comes in is quite as to what constitutes a tender.
Yes.
And one sees in some of the early cases that the judges often said we don't need to really address whether or not he's actually a tender because it's quite obviously good enough. So there may be circumstances where one of the more technical requirements for a tender isn't satisfied, but nonetheless it's sufficient to get you home. What we don't see in any of the cases is examples where none of the headline requirements are satisfied.
I follow that's the argument. I just wonder whether actually all we're really concerned with is what is good enough by way of tender, and we don't need to worry about these other contractual classifications at all.
Well,
it's a sort of a
I
red
don't-
herring.
it's not so much that one needs to worry about them, but one needs to understand, because of course what the judge found was that what these offers all were offers of settlement.
Yes.
They were effectively contractual offers, not attempts to perform the existing contract, but to say let's settle and do a deal on these terms instead. And that's why the distinction is important, because one needs to understand what the nature of these offers
But in the sense,
was.
a tender is an offer of settlement. I mean, so how does the dichotomy help?
Well,
I mean, because the relevant dichotomy is tender, yes or no. Isn't it?
I wouldn't accept that tender was an offer of settlement, my lord, in the sense of compromise. Settlement's an offer of discharge. To say, I owe you £1,000, here it is.
Yeah, well, if you're change the terminology to offer of compromise, then it's a bit easier to see the distinction. Yeah.
I mean, I suppose where it might be significant is in relation to the sums that ultimately were found not to be due to you. So if the debtor sends you a letter ex hypothesi saying you can have all that's due to you, and what about compromising on this extra in relation to the default interest claim? I mean, that's an offer of settlement. Does the fact that it includes a suggested compromise preclude tender of itself, even though they're offering all that you're entitled to?
Well, that, in my submission, wouldn't be a tender at all, because they're not coming and saying, they're making a proposal. They're writing to say, this is what I'm proposing. They're not saying, here's the money. They're not coming with the pot of gold and putting it on the table and saying, please take it. Nor are they doing anything which would be the modern equivalent of that. It's only when one gets to the point of doing whatever one decides is the modern equivalent of the bag of money on the table that one has a tender. And merely suggesting, making a proposal as to how matters might be resolved, that, whatever its terms are, cannot constitute a tender.
But suppose they did come with a bag of gold,
Yes.
and the bag of gold was sufficient to pay the principal and the rolled up interest up to the date when the bag of gold is deposited on the table,
Yes.
but there is a dispute about whether default rate interest is chargeable. Why could it not be a tender for the borrower to say, here's the bag of gold, that's everything you're due. I know this is extra dispute going on between us, and I think I can propose settling that on these terms. Would that not be a tender?
Well, I think if you're coming with the bag of gold, I think that may be a tender, I mean, perhaps depending on the other circumstances. But yes, I think that potentially would be. So you can tender money and seek to settle a dispute at the same time. I accept that, if one comes with the bag of gold.
I mean, the question might be, I suppose, is the borrower with the bag of gold saying to the lender, well, you can have the gold whether or not we settle our dispute over default rate interest. That's a tender.
Yes.
But if it's conditional on settling the other dispute, then it might not be a tender.
Yes. Well, I think that tenders have to be unconditional, subject to points about discharge of the mortgage and so forth. But essentially, they have to be unconditional. So if one's saying you can only have this money on condition that you accept it in full and final settlement of everything else, that wouldn't be a tender in my submission. Tender is saying, here I'm discharging my debt. Here, take the money that's owed to you.
I can't remember exactly what the letters say, but have in mind one of them might say, look, we suggest we pay you £1.85 million, and as to the dispute, we'll see what can be agreed or something along those lines. But the 1.85 million wasn't conditional on settling the dispute, was it?
I think it was.
Was it? Well, we'll come to it.
We'll come to it, but my submission, certainly the judge's finding, and my submission that was a right finding, was that all of these offers were conditional in various different ways.
And I'm not saying they weren't conditional in other ways. I'm just on this particular point. Does the fact that there was reference to settling the dispute mean that it was necessarily an offer of settlement which could not be a tender? Don't worry.
Well, I think that the answer is that we're talking. It's not a question of whether the offer of settlement could be a tender. An offer of settlement is an entirely different. A tender is an entirely different thing to an offer of settlement, because a tender involves coming with the money and saying, "Here it is." One might at the same time has been doing that, saying, "Let's do a deal on everything else, but here's the money." One can do that, but one needs to distinguish.
You need to
As a
make
matter of principle
the,
between-
the offer of payment, to use that dangerous word, in respect of what is due, unconditional, and anything else that you might be offering.
Yes, I recognise that I owe you this amount, here it is. That's the essence of it. We never get that in any of these letters. And really my submission is that that's what the appellants have to establish. They have to establish that there was a tender, not simply a proposal as to how matters might be dealt with. So against that background, if I can turn to the law on tender. Before getting into the detail of the authorities, I want to start, if I may, with the fundamentals of what constitutes a tender, because it's my first headline point. Tender is an attempt to discharge the outstanding debt through payment. And it's often raised as a defence. It's obviously a quite unusual defence, in the sense that you're effectively saying, yes, I accept that something is due to you, and I was ready and I am ready to pay it. So, and that ongoing willingness to pay is critical. You can't with a debt say, well, I was willing to pay you last week and you wouldn't take the money, so now I owe you nothing. It obviously doesn't work. You have to say, well, I was willing to pay you last week and I'm willing to pay you and I'm ready to pay you today, but because you refused my money last week, you can't complain about the delay in the meantime. And we see the importance of the ongoing ability to pay when one looks at how tender is normally relied upon by way of a defence. Tender before action can be raised as a claim to a defence to a debt claim. Well, there, in the CPR, Rule 37.2 provides expressly that if you're relying on the defence of tender before action, some tender must be paid into court. And of course, if that's done, then the money is there and can be paid out at the end of the dispute to discharge the debt. You can't raise the defence of tender before action, succeed in that defence, and then leave the debt paid at the end of the proceedings. The debt is inevitably repaid. And the same is true where tender is relied on in the context of an action to redeem a mortgage. My learned friend talks a lot about the notion of equity disallowing interest where there's a tender, but he didn't talk about the process by which it happens. And it's helpful, perhaps, if I could invite your lordships to turn to Halsbury's Laws at divider 27 of the authorities bundle, because one sees there how it usually works. I suspect this may be very familiar territory to my lordship. I can make the point. At page 726, it talks about the common form of an order for redemption, which directs an account of what is due to the mortgagee, and by virtue of the mortgage and for the associated costs and so on, and directs that on the mortgage or paying to the mortgagee the amount certified to be due within 6 months, and obviously longer or shorter can be given, on the specified terms, then the mortgagee has to surrender or give a statutory receipt and deliver up the title deeds. And obviously in modern circumstances it would be done differently. And it then says it further directs that if the mortgagor makes default in that payment, his claim is to stand dismissed with costs. So if you don't pay, your action just falls away. And then
I take that point, but on the other hand, it shows that you don't have to pay up front, as it were. You can have up to 6 months to pay.
Oh, well, Lord, of course, when one comes on seeking an order for redemption, of course, at that stage, one doesn't necessarily have a tender at all. One can simply be saying, I've got a mortgage, I want to redeem it, and come to court and ask for an order to that effect.
Yeah.
Time is then given to pay. Whether these days it would be 6 months one perhaps doubts, but that is the traditional period of time. But where one sees tender comes in is on the next page, where there's reference to special directions. And the last 4 lines of this paragraph, if the order for redemption is made after tender, the account is directed to what was due on the date of the tender, with consequential directions to meet the alternative results of the amount due exceeding or not exceeding the amount tendered. So in other words, if you persuade the court that you've made a tender when you bring your action to redeem, the way the court addresses that is by saying, well, directing that the account be taken as at the date of the tender, interest is calculated up to that point, and from then on, you don't pay interest. But what remains the case, and this is at 729, failure by the mortgagor to pay the amount certified due to the mortgagee within the time fixed involves the dismissal of the claim. So you, in other words, if you gain the benefit of a tender by an earlier date for the taking of the account than would otherwise apply, if you don't then pay, you lose the benefit of that tender. So the whole point, the whole essence of the way this works is that if you want to redeem the mortgage, you have to pay what is due. And an earlier tender of payment can result in a more favourable calculation, but the outstanding debt must still be paid. And if you don't, you lose it. Now, of course, neither of those routes to relying on tender is quite what we see in this case. It's not dealt with, the counterclaim is a claim for debt. But the appellants haven't responded to that by paying money into court in the usual way you would be required to do if you're defending a debt claim by a defensive tender. And they've not sought a claim for redemption either. There is authority, and it's perhaps helpful to turn it up, there is authority that shows that one can respond to a claim in debt under a mortgage by seeking an order for redemption. So one can effectively combine the two processes into one action where a claim for debt is brought. And that is helpful to look at both because it's an example of that, but also because it's actually quite close in many respects to the facts of this case. It's Caird and Trollope, and it's divided 2 of the authorities bundle at page 5. And it's a decision of Mr. Justice Sterling from 1886, and it concerns a property which was mortgaged by the defendant to the plaintiffs. The defendant then sold and assigned the equity of redemption to someone referred to in the head note as AB, and in fact one sees that was the Earl of Glasgow. And the Earl of Glasgow then borrowed again against that property. I think the original loan was for £12,000 and the second loan to the Earl of Glasgow was for £8,000. And the Earl of Glasgow was then became insolvent, and the plaintiffs brought an action against the defendants under the original mortgage for the principal money and the interest secured. And the defendants responded to that by taking up a summons seeking redemption. And the dispute, essentially, was that whether the original borrowers had just to repay the £12,000 plus interest, or whether they also had to pay the £8,000 lent to the Earl of Glasgow before they could redeem. And at the top of page 7, one sees, and this is before we get into the judgment, it's just setting out the procedural background, but on the 4th of November 1886, the plaintiffs commenced the action to recover the principal and interest due. And on the 12th of November 1886, the defendant took out a summons seeking essentially a declaration if they repaid the 12,000 plus interest, they could have redemption. That came before Master Pollock on the 18th of November 1886, and that date becomes relevant as one gets further on. The matter was then referred, and one sees it at the bottom of page 7, to Mr. Justice Sterling, and he was asked to decide whether or not both debts had to be paid before redemption could take place, and he said that only the debt owed by the original borrower had to be repaid, only the £12,000. So then there was a process by which accounts were to be taken, and those were directed some repayment, and I think repayment of the 12,000 plus interest to the 11th of February 1889 was paid. So that's an important part of the context, that the debt was discharged in full. But then we see the defendants took out a further summons, asking essentially that the certificate be varied by disallowing the plaintiff's interest on the principal sum of £12,000 subsequent to the 18th of November 1886. In other words, the date when the matter came before Master Pollock. And if one looks at the penultimate paragraph on this page, how the point was argued by Mr. Buckley, Queen's Counsel, we see the defendants, by their summons taken on the 12th of November 1886, offered to pay the amount claimed in the action with interest and costs. And on 18th November, when the summons came on for hearing, the plaintiffs refused to accept this offer. What took place then was tantamount to a tender by the defendants on the 18th of November 1886, and interest ought to cease to run to that day. And that really is precisely the argument raised by the appellants in this case. They don't rely, of course, on a summons. They rely on correspondence from their solicitors. But that's still the essence of the point. And Mr. Justice Sterling's judgment starts on page 10 of the bundle, and he begins about a third of the way down of the page by saying, well, the question was argued upon the decisions in equity, to which I shall presently refer, but it's not to be forgotten this is a common law action brought on the covenant for payment of principal and interest contained in the mortgage. And he sets out the common law test, which I think is quoted in Sterling, the decision of Lord Chief Justice Wilde in Dixon and Clark, with the various excerpts of medieval French. And then on the next page makes clear that if a plea of tender is to be successful at law, two matters are requisite. First, that the defendant must not only make the tender, but always be ready to perform entirely the contract on which the action is founded, again emphasising contractual performance. And secondly, there must be a payment into court. Then, picking it up around the middle of the page, he says the summons of 12th November 1886, which seeks a month for payment, cannot, I conceive, be treated as equivalent to a plea of tender. And even if it could, the defence would fail.
Just a minute, I've lost. Oh, I see. Yes.
Yeah, about around the middle of the page.
Yep, got it.
Lord. Can't be treated as equivalent to a plea of tender, and even if it could, defence would fail by reason of it's not being followed by payment into court. And then at the end of that paragraph, he says it wouldn't be in accordance with the principle that a court of equity should compel the mortgagee to part with an estate which become absolute at law without seeing that the mortgagor fulfilled completely his legal obligations under the mortgage deed. Now we come back to this when we get to Chukarova, but the essence of the approach is that you have to comply with your contractual obligations. And then Mr. Justice Sterling said, well, this, having looked at the position in law, he's going to turn to the position in equity, and that's his preference for dealing with it. And he refers to various cases. He refers to Giles and Hall, at the bottom paragraph of page 11, and picking up 3 lines from there, there was a question as to whether the tender was made at the proper place, and the Lord Chancellor held it was. But in this case, it ought to appear that the mortgagor from that time always kept the money ready, and that hadn't happened. And he said, therefore, the rule in equity in this respect according to the rule of law. Then Bishop and Church, in the next paragraph, there are several instances of mortgages where there are many attempts by a mortgagor to pay them off and reasonable offers of payment. Again, we see the suggestion that a reasonable offer of payment can be relied upon, but that's rejected. Yet if strict tender is not made, the court cannot stop the interest, though cases may be where the court would wish to do it. So again, emphasising the importance of tender, Garfield and Bradley is to similar effect. Hodges and Croydon Canal Company, in the bottom paragraph on that page, just picking it up 3 lines in, the defendants, the mortgagors, stated that they were ready, willing to pay the principal debt and 6 years interest, but made no tender. And Lord Langdale decided they were entitled to redeem on those terms, but they had to pay the costs. If there had been a tender of the principal and 6 years interest, then the plaintiff would have had to pay them. So again, we see there all sorts of examples of cases in which offers and expressions of readiness and willingness to pay are made without a tender, in other words, without any actual production of money, and it isn't sufficient. And at the top of page 13, Mr. Justice Sterling says, picking up at the end of the third line, in equity, no case has been cited in which interest has been stopped where there has not been an actual tender of the money due. And it is contended that the rule of equity is strict. There must be such actual tender. And he then says, I'm not satisfied that that is not placing the rule too high, which I think if one unscrambles the double negatives, he's saying he thinks maybe that may be placing the rule too high. So it may not be entirely strict, but all of the examples we see, he says there's no case where interest has been stopped where there's not been an actual tender. And he then goes on to decide the case on the basis, this is around the middle of the page, about 8 lines into the next paragraph, where no actual offer is made and advantage is not taken of the opportunity afforded by the orders to make payment into court. I think the court ought to be satisfied with the existence of that continued readiness to pay, which both at law and in equity are essential to the success of a plea of tender. And he goes on to say, well, the defendants were willing to redeem on payment of 12,000 interest and costs, but they weren't ready or willing to part with their money until it was ascertained that they could redeem on those terms. And the summons was a mechanism for determining that. But they don't get the benefit of a tender. So that really demonstrates 3 things in my submission. Firstly, it demonstrates very clearly that a mere offer of payment in the sense of a stated willingness to pay is not by itself enough to justify relief from an ongoing obligation to pay interest. That's perhaps unsurprising because the obligation is to pay the debt, not just to say you're going to pay the debt. And that remains true even where, as in this case, the creditor is advancing a demand for more than is eventually determined to be due. It's not enough for the debtor simply to say that it will pay whatever sum is properly due. The mere fact of a dispute and disagreement, even when the lender is on the wrong side of it, doesn't dispense with the requirement for tender. Secondly, it supports the principle that equity requires compliance with a party's legal and contractual obligations before it will intervene. Or perhaps, just to qualify that slightly, because it's inherent in the notion of tender, that of course the obligations haven't been finally discharged, but one has to have an attempt at compliance which is thwarted by the creditor. And again, I'll return to that theme when we move on to Chukarova. And then thirdly, as I've said, yes, the decision expresses some doubt over how strict the rule on tender is, but all of the cases cited involve a tender of funds in the sense of an attempt to make payment by producing the funds.
Well, I think it might be said, might it not, that what Mr. Justice Sterling is saying is that there may not need to be what he calls an actual tender, but then further down the page he says, I think the court ought to be satisfied of the existence of that continued readiness to pay. So that is perhaps not an actual tender in the sense of having the money, but you do need to have a continued readiness to pay.
Readiness and ability. Well, certainly he's saying the continued readiness and ability is critical. Mm. In terms of the point about the reference to actual tender in the first paragraph, he's saying that all of the cases do involve an actual tender. Yeah. It may be that there's circumstances in which one can, as I say, have nuances on that. I'll come on to some of the cases where one perhaps does see some of those nuances in play. But the situations, just preempting one, the point I'll make a little later, one sees there are some cases where the lender is either unable or unwilling to reconvey the property to the borrower. And of course, reconveyance is the other side of the coin to repayment. Hmm. And one sees where there is an unwillingness or inability to reconvey the property, the court then is a little more willing to look a bit more flexibly at what constitutes a tender, in the sense that if your lender is very clear that they can't reconvey the property, it's very difficult then to say, well, the tender was somehow technically insufficient, because it all becomes academic if the lender is saying they won't reconvey. And I'll take the court onto some of those cases in due course. But what one never has, one has the sort of flip side of the coin point about reconveyance, but one never has anything beyond that. One never sees any other sort of faults or complaint, and certainly a dispute over what is due, as one sees in Kinnard, isn't treated as something which dispenses with the need for a tender. So, we have, just stepping back for a moment, a slightly odd procedural situation in this case. The appellants seek to rely on what they say is a tender in order to reduce the debt that would otherwise be due from them. And they seek an order that LCL effectively has a judgment in its favour for that reduced sum. But of course, that debt wouldn't be discharged by any tender that was previously made, and wouldn't be discharged, as it were, by the outcome of the court decision. On the decision of the court, my learned friend was right, would simply be a judgment in favour of LCL for the relevant sum once one's excised the interest. But none of the procedures in which one normally relies on tender permit of that outcome. That, in my submission, is an indication that actually the offers which the appellants are seeking to rely really don't constitute tenders at all, and can't produce the outcome that the appellants seek. They're not seeking the sort of process one sees in a redemption action in the usual way. They're just seeking a sort of general decision from the court to disapply LCL's contractual rights to some extent, based on a tender, but without the accompanying discharge. That, in my submission, can't be right. Now, I was then going to move on to look at the requirements for a valid tender. And that I may be able to now take quite quickly, because my learned friend went through Spring and Shearer and Spring Capital this morning, and I don't need to go back over all of the points that my learned friend took the court to. I will, if I may, though, go back to some point to make some additional points on that authority, which is at divider 8 of the authorities bundle, and the relevant passage starts at page 212. I think the court was taken this morning to paragraphs 123 and 124.
Yeah.
I have also emphasised 126, which emphasises the difference between tender and discharge, and there's a reference there to Kinnaird and Trollope. One then sees, when we head at 131, the first principle, the requirement to pay the sum which is outstanding. I don't need to say much more on that. The second principle, again, you were taking to, I think, is at 139 to 140. Money must be kept available and kept aside for payment. And I think you were shown 141. No, I don't think you were shown 141. Forgive me. 141 talks about the paradigm case, which is the suitcase of cash. 143 contrasts that with the situation in Chukarova, where the sum remained in the company's account, payment of the debt for a considerable time. And there was a debate over whether or not it mattered that it wasn't legally controlled by the actual mortgagors. But the conclusion, this is the last two lines of this paragraph, which I would emphasise, the final sentence. The approach appears to have been to ask whether the money remained for practical purposes available such that it could and would be paid over at any time. And that, in my submission, is the key point. If one is asking whether the funds are sufficiently available or not, whether one's got the modern equivalent of the sack of gold to put on the table, the question has to be, is the money for practical purposes available such that it could and would be paid over at any time? And I think the court was then taken to 153 to 154 on the decision of Mr. Justice Dankworth in Barrett and Goff Thomas. And 155, I think, was mentioned, saying the tribal issues as to whether the tender in this case was sufficiently backed by finance that had been raised at the relevant date and continued to remain available. There's no suggestion at all in any of this that where the finance is merely prospective future finance, or where it doesn't continue to remain available, that would be sufficient. I was looking for the modern equivalent of money on the table. That could be, I have a refinance available who can provide funds that can immediately discharge this loan. That would be one thing. But saying, I have someone who's going to refinance this next month is entirely different. And that cannot, in my submission, possibly be the modern equivalent of money on the table. Then I think your lordships were taken to paragraph 170 and 171, which talks about conditionality. I don't need to go back over that, but if I could go back to go to paragraph 210 on page 227. I think was referred to again this morning. But 211, what the judge says, the borrower is not in a position to make a completely unconditional tender. When this is when one is tendering money from a new lender. And in those circumstances, only back any tender by saying, well, I do not have the money myself. I am just as ready and able to pay off the whole debt as I would be if I had come along with cash. The only thing I require to do so is for the security to be released at the same time and the funds will be yours. But again, that's making the point, which on my submission is the right emphasis of saying, well, you're just as ready and able to pay off the whole debt as I would be as if I'd come along with cash. That is the position that one needs to be in where there is refinancing. In my submission, the fact of refinancing makes no difference to that requirement at all. I think then the court was taken to 219 and 221, dealing with the two separate questions, whether a mortgagor can validly make a tender subject to a condition of simultaneous release of security, which the answer is yes, and whether funds are sufficiently available if they depend on if their release is conditional upon the simultaneous release of security. And it said, well, it's arguable that it would be. But there is no suggestion at all in any of this that a more general imposition of conditions is acceptable in the context of a tender. And that's unsurprising given that tender is the discharge of an existing obligation. If the borrower comes saying, oh, I will perform on this proviso, where that proviso is not part of the original contract, and you're by definition not tendering performance of the original obligation, but you're proposing an alternative basis for performance. And that, in my submission, simply cannot be a tender. Then, finally, if I could ask your lordships to move on to page 230 to look at paragraph 232. Here, the judge says there's a serious question mark as to whether and to the extent to which the cases referred to in the application above lay down strict rules on tender, which must be complied with before the court has any jurisdiction even to consider reducing interest, or whether there are rather instances of the exercise of a general equitable discretion to do so, when it's clear that a borrower is ready, willing and able to pay off the full debt and has offered the money to do so in exchange for return of security, keeping the money aside. And there is a debate, and one sees it in Chukarova, as to whether it is a rules-based system or a general equitable discretion. But the judge goes on to say, so rules, such as the fact that the full sum must be tendered, are and have remained strict. When one gets to second order points, such as the precise terms of a valid tender and the requirements of provision of draft documents in advance, the cases do not express themselves as laying down any general principles or hard and fast conditions. And that, I think, is the point that I made earlier, that yes, there may be nuances in some of the more detailed requirements, but on the fundamentals, those requirements are absolutely clear and well established and can't sensibly be departed from. And in this case, the headline requirements are clearly not met. The judge has found that, and I'll go on to address that in due course. And so the nuances and various debates about the nuances do not matter. So that's what I wanted to say on the law of tender, subject to their moving on to Chukarova. If I could invite the court to turn to that. It's tab 7 of the authorities bundle. And this, of course, is a point where the overlap between the first and second grounds of appeal really comes to the fore. Because
you're obviously not going to finish dealing with, well, I ask, are you going to finish dealing with this by the way?
Dealing with Chukarova.
Well, do you want to have 5 minutes now, or do you rather start in the morning? How are we doing for time? It's a matter of interest.
I'm doing reasonably well. There's various bits I expected to have to cover that I've skipped over because they've been dealt with already. So I'm on track as to where I thought I would be at this point.
Right.
But I'll certainly be the whole of tomorrow morning and probably a bit into the afternoon. Although that is comfortably within what my own friend and I discussed in terms of the likely timings before the case starts.
Well, do you want 5 minutes now, or would you ask?
I'm in your lordship's hands. I'm very happy to start.
Okay, let's make a start then.
Very happy to start. Now, my learned friend explained the facts, and I don't think I need to say anything more about those. Your lordships are familiar with them. One does need to remember the context, of course, that the Privy Council decided in their first judgment that relief from forfeiture should be granted. The second judgment was about the terms on which relief from forfeiture should be granted. And the debate was really about whether, as Alpha argued, the court was bound to proceed on the basis that the debt would be treated as remaining unpaid, with all of the contractual consequences following that, or whether the court had a discretion as to the terms of relief. And on that, the court was split 3-2. They were unanimous as to the outcome, but split 3-2 on the reasoning, and one sees the majority view in Lord Mance. The minority view is found in the speeches of Lord Newberger and Lord Sumption. But before turning to Lord Mance, perhaps I could just very briefly ask your lordships to look at what Lord Sumption says on page 174, paragraph 178 and 179, where he summarises very neatly the difference of principle between the majority and the minority. He says the majority believes that when the shares were appropriated to the payment of the debt on 27th of April 2007, the debt was irrevocably discharged and all the contract terms relating it to it came to an end. They will not be revived on relief from forfeiture being granted. It follows in the majority's view that the question what the borrower must pay to get relief from forfeiture cannot depend only on the contract. The terms of relief are at large, and contract is merely one factor in the exercise of a broad forensic discretion, albeit a weighty and usually conclusive one. And at 179, the minority consider that it is fundamental to the equitable jurisdiction to relieve from forfeiture that equity relieves on the ground that 1, the forfeiture of the borrower's property for what may be a trivial and rectifiable breach is penal, 2, the true intention of the parties that property should stand as security, and 3, the borrower is in principle entitled to redeem the charge over his property even after the security has been enforced. What equity does not do, in the minority's opinion, is relieve from the other terms of the contract which are not penal. It follows that those terms of the contract must determine what the debtor must do. So that really crystallises it. Is there a discretion, or is it a much more rules-based system? And the appellants rely on the decision of the majority as establishing an exceptional discretion from which they can benefit. And perhaps if I just have time to outline the 4 key difficulties with that before going on to develop them tomorrow. They are, firstly, that the discretion which the majority found to exist was a discretion regarding the terms on which relief from forfeiture should be granted. That, of course, isn't an issue in this case at all. Secondly, even if the discretion can apply in the context of a loan debt secured by a mortgage, the majority considered its application only in cases where the outstanding contractual obligations had been discharged. Where the contractual terms remain unperformed, even the majority thought those terms ought to prevail. And when one looks to the analogy drawn by Lord Mance with the mortgage tender cases, that analogy needs to be understood in that context. Thirdly, all members of the Privy Council recognise that a tender of money due and under a mortgage will stop interest running only if the money is set aside and kept ready to pay the debt. And of course, as the judge found, that didn't happen in this case, and there's no real suggestion that it did. And fourthly, nothing in Chukarova suggests that there is a general discretion to discard contractual terms which were unperformed and where performance had not been tendered. Or perhaps I can come back to developing that
Yes.
in the morning.
Yes, thank you very much. 10:30 tomorrow.
So I'm able